In the realm of law, evidence reigns supreme. It is the bedrock upon which justice is built, the compass guiding judges and juries towards truth and fairness. Without evidence, legal proceedings would devolve into mere conjecture, leaving the fate of individuals hanging precariously on speculation and guesswork. Evidence comes in many forms, each playing a crucial role in illuminating the events in question. From eyewitness accounts to tangible objects, every piece of admissible evidence contributes to the construction of a comprehensive narrative, allowing the court to piece together the puzzle of a case. The importance of evidence cannot be overstated. It has the power to exonerate the innocent and hold the guilty accountable, ensuring that justice is served. It is through the meticulous presentation and examination of evidence that the legal system strives to achieve its ultimate goal, a fair and impartial resolution to disputes. Whether a civil matter or a criminal case, the strength and credibility of the evidence presented can mean the difference between victory and defeat. It is the responsibility of legal professionals to navigate the complexities of evidence, ensuring that admissible and relevant information is brought before the court. The legal world classifies evidence into various types, each with its own characteristics and weight in court. Among the most common are oral evidence and documentary evidence, both crucial in painting a complete picture of a case. Oral evidence, as the name suggests, involves spoken words. It encompasses testimonies given by witnesses, experts, and even the parties involved in the case. The court assesses oral evidence for its clarity, consistency, and credibility, taking into account factors like the demeanor of the speaker and any potential biases. Documentary evidence, on the other hand, exists in written or printed form. This category encompasses a wide array of materials, from contracts and agreements to letters, emails, and even social media posts. The authenticity and reliability of documentary evidence are paramount, with specific rules governing their admissibility in court. Both oral and documentary evidence play vital roles in legal proceedings. While oral evidence provides direct accounts and insights from individuals involved, documentary evidence offers tangible records that can corroborate or contradict testimonies. The interplay between these two types of evidence often holds the key to unraveling the truth behind a claim. Understanding the nuances of different types of evidence is essential for legal professionals. Properly presenting, challenging, and interpreting evidence is crucial for effectively advocating for one's client and ensuring a just outcome in court. In everyday conversation, the Word document conjures up images of printed papers, reports, or official records. However, within the legal sphere, the definition of a document extends far beyond these traditional notions. Legally speaking, a document encompasses any material bearing information that can be used as evidence in court. This broad definition includes not only written or printed matter, but also electronic records, photographs, maps, drawings, and even audio or video recordings. The key element that elevates something to the status of a document in the eyes of the law is its ability to convey information relevant to the case at hand. A crumpled note found at a crime scene, a digital spreadsheet containing financial records, or a car RDR baif or depar ani surveillance video capturing an event can all be considered documents if they hold evidentiary value. This expansive definition reflects the evolving nature of information and communication in modern society. As technology advances, the forms of evidence considered documents continue to expand, encompassing new and innovative ways. Information is created, stored, and presented. Understanding this broad legal definition of a document is crucial for lawyers, judges, and anyone involved in legal proceedings. It ensures that all potential sources of evidence are considered and that no stone is left unturned in the pursuit of justice. Section 4. Public documents. Records of our society. Public documents hold a unique place within the legal system. These documents, created or maintained by government entities, serve as official records of societal activities, holding information crucial for legal proceedings and historical preservation. Several categories define public documents, each with its own significance. Sovereign authority. Documents emanating from the highest levels of government, such as legislation, executive orders, and treaties, fall under this category. Official bodies' records generated by government agencies, departments, and ministries, including reports, minutes of meetings, and policy documents, are considered public documents. Public officers' documents created or certified by individuals holding public office, like birth certificates, marriage licenses, and death certificates, are categorized as public documents. Public records or private documents. When private documents such as deeds, mortgages, or wills are registered with a government entity, they become part of the public record. Documents in judicial proceedings, court filings, judgments, orders, and transcripts from legal proceedings are all considered public documents. Maintained by public servants, records generated and kept by public servants in their official capacity, like police reports or inspection reports, fall into this category. Registered documents. Documents requiring registration with a government body, such as trademarks, patents, and copyrights, are considered public documents. Certificates, documents issued by government authorities to certify a fact, like a certificate of incorporation or a driver's license, are public documents. Understanding the different categories of public documents is essential for navigating legal research, supporting claims, and establishing facts in court. These documents provide a wealth of information and often serve as crucial pieces of evidence in various legal matters. Section 5. Private documents, personal and confidential. In contrast to public documents, which are created or maintained by government entities, private documents belong to individuals or private organizations. These documents contain personal or confidential information and are not generally accessible to the public. Examples of private documents include personal letters and diaries. These handwritten or digital documents contain private thoughts, feelings, and communications. Medical records. Information about an individual's health history, diagnosis, and treatments is considered confidential and protected by privacy laws. Financial statements. Bank statements, tax returns, and investment records reveal individuals and an individual's financial status and are treated as private documents. Contracts and agreements, documents outlining the terms of an agreement between private parties, such as employment contracts or lease agreements, are private. Internal company documents. Memos, emails, and reports created within a company for internal purposes are generally considered private documents. While private documents are not publicly available, they can become relevant in legal proceedings under certain circumstances. For example, a private contract might be submitted as evidence in a breach of contract lawsuit, or medical records could be subpoenaed in a personal injury case. The admissibility of private documents in court is subject to rules of evidence, which balance the need for relevant information with the protection of individual privacy. Understanding the distinction between public and private documents is crucial for protecting confidential information and ensuring that legal proceedings are conducted fairly.